Hello, everyone, and welcome to Internet Law Review. So, this is just a quick tongue in cheek response to Steve Lehto, who recently did a video on his channel discussing a particular case that is famous for being written in the form of a poem. And Steve expressed some displeasure that it is written in the form of a poem because he says, and with some justification, that courts should take people seriously and be places that are serious and look at things seriously. And he says that courts should probably not just play around and have fun, and they should always treat everyone with respect. Now, on one hand, of course, I appreciate and respect that. I think courts should respect people, but from time to time, I think courts are allowed to let their hair down, as it were, and allow things to be done in a more informal way. I mean, there are some people who do enjoy the occasional legal opinion written in the form of a poem. Welcome to Internet Law Review, you cool cats. Today we've got something different for you. It is the U.S. Supreme Court case of Rahif versus United States. But rather than read what the court wrote, I have rewritten it in the form of a slam poem. So let's hear the cool, dulcet tones that is Rahif versus United States. So on screen is the case that Steve was referring to. This is the case of Fisher v. Lowe, and this is what the court actually wrote in their opinion. You can read for yourself. It's written in the form of a poem. And basically what happened is a person struck a tree with a car. This happened in Michigan, and Michigan has what's called no-fault insurance. So basically what happens, especially for auto accidents, is that when someone is in a wreck, your own insurance pays you rather than their insurance. So you can file for a claim, but you don't file a claim against the person who injured you. You file a claim against basically yourself, your own insurance, to pay you. And the idea is to help simplify some auto accidents by not having to really sort out who's responsible. You just say that something bad happened, there's some damages, and you file against yourself, basically. In many other states, this is optional. For example, in my state of Virginia, I have insurance for myself as well as against the other motorist. So in the event of a car accident, I could file against myself, or I can file against the other insurance company. And if I file against myself, my insurance company will pay me out and then sue them on my behalf. But it's up to me to pick one or the other. But I'm insured for myself, and also I can go after their insurance. And the reason I insure myself is because if they don't have insurance, or they don't have enough insurance, which is not exactly outside the realm of possibility, then I've insured myself, and I'll be able to take home what I need to take home to make me whole. But the state of Michigan doesn't work like that. It just basically says if you want insurance with respect to automobile accidents, you have to compensate yourself. So what happened in this particular situation is there's an automobile accident. The automobile damaged a tree. The person tried to sue the person who drove the car, but they couldn't because of this law. So basically it says you can get the damages, but you have to get it against presumably your own homeowner's insurance, assuming you have it, which I really hope they do because they should have it for a whole host of reasons. But they can get recovery, but Michigan says not from the person who damaged them because Michigan says automobile accidents happen. So we're not going to deal with people suing each other in court. Just no fault is the rule, and we'll deal with it from there. But since this was all in all a fairly simple case, court chose to write it in the form of a poem, and man, I dig it, baby. But for now, my friends, that is all. Once again, this is the cool tones of Internet Law Review. Hope you're having a great night. Till later, friends. Cool cats. You stay right out there, baby.